Next on the calendar is number 105, People versus Jamell McCullough.
Good afternoon, Your Honors. Scott Miles on behalf of the people.
Would you like rebuttal time?
Yes, Your Honor. 2 minutes, please.
Yes.
Whether or not to admit expert testimony is a decision which is best left to the sound discretion of the trial court. The trial court in this case did not abuse its discretion by precluding the introduction of expert testimony as to the reliability of eyewitness identification, because this was not a case where there was little or no corroborating evidence. There was a single eyewitness in this case. However, his testimony was corroborated by the testimony of a cooperating co-defendant.
Counsel, let's say we get rid of that test, just hypothetically. If Legrand is not good law after Holmes, and you're looking at a pure abuse of discretion standard here, what would the test be then? Well, how would this factor into whether the judge abused his discretion or not?
I believe if we get rid of the Legrand test, the only question, are you saying if we simply use simple rules of evidence as to whether or not to
For any other expert testimony you would admit?
At that point, the only question would be whether the expert had information which would be relevant to the question at bar. And in that case, I can't imagine any trial that would not simply devolve into a battle of experts.
But wouldn't a trial judge then still have discretion to say, even if this expert testimony is in some way relevant, I can preclude it because its relevance is outweighed by undue prejudice, or it's it's extraneous or whatever? Wouldn't that balancing test still take place? And isn't that the point where you can consider the Legrand factors?
I'm sorry. The point, if the trial judge is making the determination that other factors outweigh the relevance of the expert testimony. Well, Your Honor, I believe the Legrand test is still the better method because it has the two-part balancing test.
But my concern with Legrand is Holmes, right? And if you're looking at really the strength of the people's case in considering whether or not testimony comes in, right? So it's not a third-party accusation, but it's the defendant's evidence, right, what the defendant wants to put on. And we're saying before you get to a regular balancing test, you have to jump through these hoops. And one of them is the corroboration requirement that or the corroboration analysis that you just described. So if we're going to say that isn't any good under Holmes, let's just say we do that, or we consider doing that, then what would the standard be?
The standard would be simple relevance, and whether or not the relevance of the testimony is outweighed by undue prejudice to either side. And the outcome would be similar to the Legrand test. However, I believe, again, Legrand is still the better option because when you're dealing with specifically expert testimony on the reliability of eyewitness identification, you run the risk of confusing the issue, confusing the jury with issues that are extraneous to the central determination. It's taking the determination out of the hands of the jury, the determination of whether or not the eyewitness's testimony is reliable.
But isn't that can't you get to that same place using the standard admissibility criteria for expert testimony and the balancing test without having the Legrand preliminary hurdle?
You can, but again, you run the risk of tipping the balance too far to the other side, essentially, of requiring trial courts to admit expert testimony when that is not really a question that is properly before, or rather.
Put it another way, once you admit that expert testimony is necessary, let's say that in any eyewitness case, once that threshold is crossed, then why should this expert testimony be treated any differently than any other expert testimony? We have expert testimony in all sorts of evidentiary issues that the courts rule and let it in. So I guess the question that strikes me is that what's different about eyewitness testimony than will be different about another form of testimony where we do allow scientific evidence outside the ken of the jury to supplement their analysis of it? Why should it be different here than anywhere else?
Because the determination of an eyewitness's credibility and reliability has always been a central determination to be made by the jury, who are in the position of observing that witness and determining for themselves, really, in many cases, the very central question that the trial is being held
So what you're
for.
saying is that the juror's evaluation of the corroborating witness then is something that they have that person right in front of them, and that's a normal human thing to do. You see whether they're telling the truth or not, whether or not what they're saying is credible, given this guy's background and everything. That kind of evaluation should only be made by a jury of your peers and can't be supplemented by an expert. But it seems to be a number of cases out there where eyewitness testimony has been wrong, and it's been, even though it's been corroborated, and that's the argument that's behind why we should be allowing expert testimony, so that that's factored into the jury's analysis.
That's true, Your Honor. However, the balancing test is, I believe, specifically implemented to avoid the situation which would arise if...
Which is what Judge Garcia was saying. That's where you would end up with the balancing test of prejudicial or probative value versus prejudicial effect, and then abuse of discretion, those two.
Correct. But I believe what would happen were we to simply rely on the standard evidentiary rules rather than the Legrand test is that every single case, instead of having a jury determine the reliability, the credibility of the witness who is testifying before them, they are instead relying on simply which expert testifying for the defense or for the people they find to be more credible, rather than the witness themselves.
Is the validity of Legrand before us in this case? I know the amici have raised this.
I know there are certainly parties who would like it to be before this court. However, it's the people's position. The people are not arguing the validity of Legrand. Certainly, the people argue simply that under the facts and circumstances of this case, relying on Legrand, the appellate division came to the incorrect conclusion by deciding that there was insufficient corroborating evidence in this case to obviate the need or the requirement for the expert testimony.
Are there circumstances under which a co-participant might not be able to corroborate an eyewitness, a single eyewitness?
I can certainly imagine there might be circumstances if the accomplice never had the opportunity to view the other accomplice. For instance, if they were all masked during the entire.
Well, what about in this case? As I understood defense counsel's argument in part is that the co-participant may have very well observed the defendant at some point, but did not observe anything that went on inside the barbershop. And that's where the expert might have provided some useful information to the jury to appreciate the eyewitness's observations of the events inside the barbershop. Why doesn't that work?
Your Honor, actually, I believe the fact that the corroborating witness did not see the same events as the victim, the surviving victim who testified, actually makes it even stronger corroboration, because the expert testimony would have been on weapon focus, event stress, those issues, which only apply to the surviving victim inside the barbershop. The corroborating witness, the accomplice, saw the defendant before the crime. Immediately, as the other people were walking into the barbershop, he saw them after the crime, and he saw them again when they were dividing up the proceeds of the crime. So none of the expert testimony as to those factors would have applied to the corroborating witness in any way.
Thank you, counsel.
Thank you.
Counsel?
May it please the Court, Brian Schifrin on behalf of Jamell McCullough. It's our contention that the Appellate Division 4th Department was correct under the Legrand test, and as I'll argue in a moment, if the Court were in fact to hold it was correct to preclude Mr. McCullough from the opportunity to present an expert on the factors affecting the reliability of identification that pertain to his particular case, such a ruling would demonstrate that is urged by amicus, that in fact the Legrand rule actually implicates.
I read the Legrand rule a little differently. I didn't think Legrand was saying sufficient corroborating evidence was a threshold determination to be made by the trial court. I thought it was, in looking back on appellate review, whether, whether preclusion of the expert testimony wouldn't require reversal as long as there was some corroborating evidence. To me, those are different things.
And what happened here is, with respect to the appellate division, is what this Court did in Santiago and in Abney. This Court in Santiago had a case where there was the identification, and there were two corroborating eyewitnesses, two other people. This Court held that the Court erred in not getting to the Frye hearing by its holding that because there were two additional witnesses who presented corroboration, both eyewitnesses, both strangers, and it's important, people who did not know Mr. Santiago before, this Court ruled there was error for the trial court not to reach the Frye issue. Indeed, in Santiago, the Court pointed out that similarly in LeGrand, there had been a witness besides the eyewitness, the immediate eyewitness. There was actually two secondary witnesses who, again, were strangers. And finally, in Abney, which was actually two cases, Abney and Allen, the Court distinguished Abney from Allen because in Allen, what the Court held to be critical was that the corroborating witness already knew the defendant, and therefore identification wasn't a critical issue. Similarly, in People v. Young, relied on by the appellant, this Court held that the trial court did not err in precluding the eyewitness expert because there were two accomplice witnesses there were two prosecution witnesses who were acquaintance of Mr. Young, both of whom testified that the stolen property in their possession came from Mr. Young. So therefore,
it sounds like, counsel, that you're saying that the determinative factor here is that Mr. Harvey didn't know the defendant before the crime took place.
That's one of the factors. The factors that go both to reliability of his testimony and to credibility. With respect to reliability, he was a stranger. He testified he never knew my client prior to that event. Number two, he failed to identify my client in a photo array at a time that he picked out his own brother and his cousin. One would think, before you identify your brother as a participant in a robbery murder, you would pick out someone else.
Isn't that what you get down to in terms of what the trial judge is deciding? He's got Johnson who says that's the guy. He's got this other person who says that's the guy, but previously he said that's not the guy. And he's one that was involved in the robbery. So a judge could, under those circumstances, say this is not a LeGrand issue. This is a credibility issue with respect to Harvey. So that's for the jury to decide, not for me. If they want to believe Harvey and say, he corroborates Johnson and they both put him at the scene, fine. If they don't, because of all the things that you have brought out and about to, that's fine too. But there's no reason to say that Johnson didn't have an opportunity to see him properly and Harvey didn't have an opportunity to see him properly, and the question whether Harvey's telling the truth or not is for the jury.
A few things in response. First of all, I think there's a difference between reliability factors and credibility factors. This Court, in a decision that you authored in Santiago, held that the trial judge was wrong in not getting past the corroboration issue and holding that because there were two corroborating witnesses were done. This Court rejected the conclusion that a court can determine it when it goes to reliability. The reliability factor, besides being a stranger, was the failure to identify.
Aren't you then saying there must always, always, always be a LeGrand expert in any eyewitness case?
No. First of all, under LeGrand, this Court's distinction has been two things, as pointed out by Judge Abdus-Salam, whether it was a stranger or not, and also whether or not there was possibility of unconscious prior transfer, prior observation. Because Mr. Harvey had seen the photograph of my client previously, he was the only person in the initial photo array that was in the photo array 14 months later. It's amazing. He had never seen my client previously, but
he had a fair amount of opportunity to see him that night.
And yet,
it wasn't a fleeting thing, and he wasn't under any stress or pressure of the situation at the time when he first saw him and met him, and there were no weapons involved. So, I mean, aren't those indicia of reliability?
Perhaps they would have been if he had identified him, but actually, no, Your Honor. Respectfully, what we know is stranger IDs fail, and the amicus brief points out numerous cases with multiple stranger IDs are wrong.
Well, isn't the failure to identify him getting to your credibility question? Because he gave an explanation of what he said. He really did identify him. He just didn't want to.
That goes in P. versus Santiago. The corroborating witness also gave an explanation. He was worried about his immigration consequences if he testified because he was undocumented. And yet, again, this Court held the fact that that witness had an explanation for his prior failure to identify was not a sufficient basis to say, well, there was corroboration. If in fact, given what we know, which is from DNA exonerations, that misidentification is the leading cause of wrongful convictions, because a witness saying that's the one is understandably powerful evidence, even if sincere but wrong.
I think everyone knows that. I think we're on to the second part. In other words, Johnson's Johnson. Johnson says that's the guy. Whether you believe him or not, maybe you've got a point with respect to, we need LeGrand. But when you got somebody else who, as Judge Stein's pointing out, is a participant, at least to some extent in this thing, or not, and who makes an identification or not, aren't you down to credibility? In other words, there's nothing reliable about him. I mean, he was there. So you either saw him or didn't, and you got to believe him or not.
A few things, again. First of all, with respect to Johnson, he first identified the person as the shorter, darker person wearing dark clothing.
What you're doing is you're replacing yourself with Judge Valentino. You're saying Judge Valentino was flat out wrong because the guy was shorter, was this, was that. Looking at it broadly as a matter of law, you have a judge that says, here's somebody that identified the defendant. Here's another person who identified the defendant. Both of them have scars. This guy's got a major credibility problem, but I've looked at it all, and I know how this thing unfolded. I know the debt, I know the timing, I know how everything occurred, and I don't think LeGrand is going to help us.
A holding that a judge can make his or her own determination that I think that a stranger ID by someone who previously failed to identify the person is sufficiently credible to preclude a defendant's right to present evidence would be an abuse of discretion as a matter of law, because this Court held in People v. Huddy the limits of discretion are the defendant's constitutional right to present a defense. If, in fact, under LeGrand, a court can say, well, in my opinion, that's reliable ID, and talk about not having a jury decide, having a judge decide that, we in fact limit a defendant's right. The most critical evidence in an ID case.
And is that in part, if I'm understanding part of your argument here, and is that in part because if the jury were to discount Harvey's testimony, they are then left with Johnson, and they now are left without this expert testimony that might assist the jury in determining whether or not Johnson could identify the defendant. Is this your point?
In this case, there's good reason to believe the jury did not consider, did not credit Mr. Harvey. They didn't ask for his testimony to be reread. They asked for Mr. Johnson's testimony to be reread. Mr. Johnson, pardon me, Mr. Harvey.
I get that, but so let me ask a different question. So you say yes to that. So then did defense counsel make this argument below?
The defense argument.
Can I find this in the transcript, this particular argument?
The argument was that the argument that Mr. Harvey was not so credible and reliable.
Yes.
When the motion was renewed at the end of the case. Yes, Your Honor. Again, the fact that well,
I looked at that transcript and I looked at that argument and I saw maybe one sentence for you to stand behind, and it's a pretty weak one, out of pages of argumentation where he's focusing on Harvey did not observe what went on in the barbershop. And that was what I understood counsel to be arguing. So therefore, he cannot corroborate what went on in the barbershop.
Respectfully, I believe counsel also argued that Harvey was simply not credible. As the DA described him as a liar. He self-admitted liar. What he testified to was different than what he said during the plea. To say, well, because this admitted liar came in, we can therefore ignore the issues of reliability of identification.
Well, I agree with you. Defense counsel may have attempted to discredit, if you will, this particular witness, Harvey, but to actually have based his motion on Harvey's credibility is
not the initial,
very weak, and therefore I should still have the expert because Harvey cannot be believed for purposes of the identification in the barbershop?
Again, I believe when the motion was renewed, the answer is yes, and in any event, any ruling that would preclude this on the most critical evidence or ID, we believe would be an abuse of discretion because it would violate a defendant's critical constitutional rights.
Was there any argument below by defendant that the expert's testimony would be relevant as to Mr. Harvey's identification?
There was I have to be careful. The pretrial motion specified 3 separate grounds: weapons focus, the stressful nature of the event, and the duration. I don't recall if that issue ended up being addressed because the focus, the initial pretrial ruling was
to Mr. Harvey. I'm talking about.
Oh no, not with respect to Mr. Harvey.
His eyewitness.
I do not believe so. I believe the focus was on Mr. Johnson because again the contention was Mr. Harvey was neither reliable nor credible.
Thank you, counsel.
Thank you.
Mr. Miles.
Your Honors, again, the question of credibility, the credibility of the corroborating evidence in any eyewitness case is a question that is best left to the discretion of the trial court because it's difficult to imagine any type of corroborating evidence whose credibility could not be attacked.
But what's the downside? If Legrand's expert came in and said what she was going to say, which, weapons, focus, stress, et cetera, you'd still be arguing it makes absolutely no difference. That's a fog. The fact of the matter is that Johnson identified the defendant. Mr. Harvey identified he has his flaws and scars, but he's still there. So it doesn't make any difference what she's saying because you got 2 people say he did it.
That is precisely why the rule exists, to not distract a jury with evidence which has no real bearing on their determination, the determination that they are there to make, whether or not the witnesses saw what they claim to have seen and whether or not they're credible and reliable.
Counsel, I read this case slightly differently. I thought the judge was initially willing to allow the testimony of the expert, but because of scheduling, there might have been a problem.
The scheduling question essentially was never really reached because the judge decided it on the first part of the Legrand test. The judge did consider the motion for the expert testimony. However, he took the papers back and there was a recess. He looked at everything and then he came back and said that he was making the determination that based on what he knew or suspected was going to be the people's proof, that the defense's motion would fail under the first part of the Legrand test.
Did he say that in the context of a Frye hearing? Or am I confused?
There was, the people did argue in the alternative. They argued that there was sufficient corroboration to obviate the need for the expert testimony, and they also argued in the alternative that if the judge determined that there was not sufficient corroboration, that a Frye hearing would be necessary. And the judge did determine that he did deny a Frye hearing, but he did so under the fact that the proposed testimony would fail under the first part of the Legrand test. So essentially, he never really reached whether or not a Frye hearing was going to be necessary because of the nature of the evidence. He simply denied it because the testimony itself was not going to be coming in.
Counsel, does it matter that the Harvey does not observe anything in the barbershop, that can't corroborate what goes on in the barbershop? Does it matter? I know it's a felony murder case, I know it's accomplice theory. Does that matter? That all he's corroborating at best is that the defendant was in the car, went into the barbershop, and came out of the barbershop?
Well, the corroboration we're looking for is as to the identity of the defendant, whether or not he was the person who was actually inside the barbershop.
Right.
Johnson's testimony about what the defendant did while he was in the barbershop and what everybody, all of the robbers did, is very credible and reliable in itself.
I understand, but it's uncorroborated, is it not?
That's true.
He's the only person who can testify as to what went in because he's the surviving victim.
The only survivor, that's correct. But again, when we're dealing solely...
No, I'm asking you, does it matter in this case?
It does not matter, no, because we're dealing solely with whether or not the defendant was one of the people who went into the barbershop and participated in the robbery, not what he did when he was in the barbershop, not whether he was the shooter or one of the people with a weapon. The question is...
What's the evidence to find him guilty of the felony murder, then?
That he was participating in the robbery. And
but doesn't that only come from Johnson?
No, it does not, because after the robbery occurred, Mr. Harvey also witnessed the individuals who went into the barbershop dividing up the proceeds of the robbery.
Thank you, counsel.
Thank you.